Welcome to the 2026 Dialogue, a masterclass series by the HR Association of India. I am Neha Jignani, and today we are exploring a theme that sits at the intersection of law, leadership, and business strategy. How organizations can effectively navigate conflicts in an increasingly complex environment. Our theme for the session today is navigating business conflict, litigate, negotiate, and resolve. To explore this, we are joined by Ruchi Agnihotri. Ruchi is a seasoned counsel, arbitrator, independent director, and entrepreneur with over 26 years of experience in dispute resolution and corporate advisory. Her expertise span arbitration, white collar crimes, corporate litigation, and strategic risk avoidance. She has held leadership roles at Shardul, Amarchand, Mangaldas, and DSK Legal, and served as General Counsel at Hindustan Power. She is a member of the Delhi High Court Bar Association and COMBAR. She also co-founded Perigonia Pvt Limited, a sustainability-driven wellness venture. Ruchi, thank you so much for joining. It's a pleasure having you.
Hi Neha, thank you for having me on the show. Thank you for the extremely kind introduction. And I hope I live up to this introduction. I think let's straight away deep dive into your questions.
Absolutely. Looking forward to this exciting masterclass, Ruchi. So, to begin with, my first question is what are some of the most common business conflicts that organizations face today, and how has these evolved with the rise of startups and technology driven business models?
You know, the great disruptor that has just come about, which is AI, that's really sort of quite the pitch. But even before AI had come,
Hmm.
disputes have been changing character over the years, from being labor union, industrial disputes to the post-liberalization era where we had, so many corporate mergers, demergers, reverse mergers, schemes of arrangement, compromise, a lot of foreign investment. And then comes the era where we have the scams, as we call them, the 2G scams, the Commonwealth Games, which also changed the landscape of how commercial business conflicts were looking at. We were the way we look at commercial business conflicts. And today we have an era where data, it's all about data. To give you an example, intellectual property. When I joined the profession, I in fact did 1 year before I joined Amarchand Mangaldas, where I spent 16 years of my career. I was with a lawyer who's now a judge of the Delhi High Court, and she was a specialist IPR lawyer. And at that time, in the early 2000s, it was all about trademarks. Um, then it was all about copyrights and etc. Today we are looking at complicated patents, data-driven AI models, which are in the intellectual property domain. So if you just look at intellectual property disputes, they have evolved, so dramatically over the past 3 to 4, decades, so to speak. The same thing happens in, say, an HR space. Yeah, from labor relationships with management. It is now an era where we have more and more white collar employees, that are not necessarily workers or covered by the Industrial Disputes Act, etc. So but there are conflicts, there are disputes, So you do have HR related issues. You do have then the Vishakha guidelines, which finally led us to have our, Sexual Harassment at Workplace Act, which is called the POSH, which mandates certain very important, internal governance principles that have to come into any organization that employs more than a certain number of people. You have to have a, sort of a POSH committee and other things. That is also a business conflict because tomorrow, if you have a high profile exit, like for example, the high profile exit we just saw in HDFC Bank, or the high profile exit that we saw in KRBL, the Basmati Rice group, um, it raises questions. Why did this independent director, why did this chairman resign? What happened? What was happening there? Um, Investor confidence gets a little shaken. Um, your for a bank, your the people who have entrusted you with their life savings and various investments, they start feeling a little shaky. What's happening here? Right? So yes, disputes have evolved, they've changed color, and there is a lot that corporates now need to do in terms of, we can't simply call it compliance. When I joined the profession, Neha, there were hardly any in-house legal professionals in companies. And today you have in-house legal teams that are running into 10 plus, 20 plus. For example, Bharti Airtel, etc., actually has more than 50 or 60 people just in their legal in-house sort of vertical. So, compliance is something that has really sort of changed the name of the game. And there, for example, again, operation and mismanagement was what we used to see a lot in the early 2000s. Today, you don't see so much. Maybe you see a bit from, say, like the Cyrus Mistry Tata's dispute last decade. But you today see very different kind of shareholder disputes, because you have a startup ecosystem, you have investors that come in, you have a seed funding round, you have a series A, B, C, D, etc., etc. And at different levels, you have different levels of investors that have a stake in your commercial enterprise.
Sure.
And so therefore disputes are also looking different in terms of even in shareholder disputes. And what is coming before your, even if you're not a listed company, but you are an app, you're a startup, you have people that are interacting with you, by availing of your services or availing of your app or whatever it is that you're offering to them. It raises the bar for the kind of, like, say, data. You need to be very careful on how you're using their data, because if you violate or breach their data and give it off to some other platform inadvertently or with, even consciously, you have a whole set of issues to deal with under the new data privacy laws. So
Sure.
yes, it's become very nuanced. And what it has led to from a lawyer's perspective is that you have a place for super, super, super specialization.
Sure. Thank you so much. Truly, it has evolved. Earlier, as you rightly mentioned, it was only about copyrights and trademarks. And till now, which is complicated patents, IPD, as you rightly said, um, you know, compliance is the need of the hour. You have to do that. And earlier, as you rightly said, there were not many people in the legal, but now you see that evolving, a big team of legal in-house teams. It actually speaks for itself. And operations and management, mismanagement, as you rightly said, which was there earlier, it's not anymore. So much has changed through the course of some time now. So thank you so much for putting it together. My next question, Ruchi, is with the changing nature of business disputes, have you seen a shift in strategies organizations, adopt to manage and resolve the conflicts? And what approaches are proving more effective today?
See, dispute resolution by itself has in it the strategy interwoven, the term itself. It is something where a conflict has arisen, or a disagreement or a difference of opinion has arisen, whether between two individuals or between two corporates or between two entities or whatever it is. And the idea is to resolve it. The idea is to resolve it. Now, litigation is one technique of resolution where you um, escalate the conflict. You escalate the conflict.
Right.
Negotiation is another technique of resolution where you bring people to a discussion point and say, let's understand what's, this is my pain point. What is your pain point? And let's see how to minimize our pain points and maximize and take away some sort of a win-win from this. You concede a bit, I concede a bit. It's very similar to what's there in matrimonial disputes or even family disputes. It comes to the same thing. You give some, I give some, and we come to a middle ground.
Yeah.
So when you say whether to litigate, whether to negotiate, or how to resolve, basically it all goes towards that, right? Sometimes, as external legal counsel, which is what I have been essentially most of my life, my in-house stint lasted a grand total of 2.5 years. In my I'm completing almost 27 years now in the profession. Uh, litigation also is suggested only as a means of bringing a satisfactory resolution of the situation. Sometimes you cannot, even if the intent is to bring the other party to come and discuss or settle the issue, you sometimes need to get that stay. I'll give you an example. The most important thing is, we'll come to that later. I think it's one of the questions. But that is essentially the purpose of litigation.
Right.
Bring them to the negotiating table, right? Or come to a via media that is acceptable. Yes, in a criminal dispute, it's a very different situation because there it's a penal offense and it's considered an offense against the state. So the private parties' stakes go down, so which includes white collar crimes. Because if you're doing something that is depriving the public exchequer of funds, then your liability increases to that much level. We have ADR now, which is commonly alternate dispute resolution, in which you have arbitration and conciliation. And conciliation has now been clothed with a new term called mediation. And there is now a Mediation Act of 2023. And in fact, our Chief Justice of India and various public sector enterprises and government departments have issued statements saying mediate. Mediate is nothing except bringing parties, for example, if I'm a mediator, I just bring parties as a facilitator in front of each other, and
Sure.
I help them talk to each other and help them resolve their differences. The idea is to reduce the backlog, to reduce the pendency of courts. So companies have to adopt nuanced approaches. The idea should always be to avoid a litigation, even though I'm a litigator primarily. But the idea always is avoid a litigation, avoid getting into a scenario where you have to actually initiate. So there are these very, crafted dispute resolution clauses that are there in the contracts, or whatever is the parent document that defines the contractual equations between you and the counterparty, right?
Sure.
And they will give you your step by step process. So they'll have a step saying negotiate this or try to take it to conciliation or mediation. And then if there's an arbitration clause, then you have to go by arbitration. Arbitration it's just a court proceeding, but it's
Sure.
just faster and it's not done by judges.
Okay.
So yeah, it's you have to take that call at that point of time.
Sure, sure. Thank you so much. Very informative indeed. My next question, Ruchi, is senior management exit, often create both workplace disruption and, potential legal exposure. So from your perspective, how should organization handle such situations and what systems can be put into place to, manage these more effectively going forward?
So, senior management exits have a very wide-ranging impact on the organization, right? Because they are literally the face of that organization in that sense, and not only the world outside, but even the employees within that organization identify a lot with that person or team of people, right? Sometimes in an entire senior management team exits or something like that. When somebody exits like that and does not exit because they're moving on to a better opportunity or something like that, or exits because there is some friction with either the promoters or there is some internal issue within the organization that is flagged as a reason for the exit, that creates an even more complicated sort of situation, right?
Right.
Because if you're a listed company, you have to manage what your regulator is going to ask you. Let's say if you're not even a listed company, you are a listed company or whatever, you're a bank, then RBI will have its own set of questions. Your regulator or SEBI will have its own set of questions. If you're a listed company and a bank, then RBI and SEBI both will have their own set of questions, and you will have to satisfy them. Your shareholders will want to know what has happened. Media will have its own set of questions, and internally, Your own employees will have their own set of questions and situations. So there is a lot of very fragile, delicate management that has to be immediately done. And therefore, one, you have to have very good, robust systems in place. Two, Indian promoter driven enterprises, lots of times, there's been a big change in the past 15, 20 years. But even now, you'll still find a lot of very big companies, very, very big companies that are very family driven or very personality driven, right? And where you do not really empower your CHRO, or you do not really empower your CEO and your CFO to that level that they can take those calls, because these are things that have to be taken at that very instant, right? And if you have systems in place and your CHRO knows what they have to do, they immediately come and they give you the protocol, that this is what media approaches you, this is what you say, regulator asks you a question, this is the email that you send, etc., etc., etc. Your in-house legal team has to be very, very good and robust for you to be able, they can just come to you and say, do this. And the in-house legal team should know exactly when to get that external counsel opinion, and involve that, because it could be reputational damage, it could be regulator, for example, in one of the white collar crimes investigations that I did, there was a Cobra Post sting operation on certain banks, and how the employees at their different branches had said various things to customers in a bid to sort of win that account or whatever, which was construed to be anti the KYC and money laundering regulations, etc., etc. So RBI was doing its own investigation, and the banks were also getting external counsels like us, along with forensic investigative agencies like Deloitte or KPMG, etc., to do the investigation. And in real time, there were so many things to do. You had an RBI team sitting in your office, at your head office, corporate office, checking everything, and you had external counsels who were doing their own end of it. And then there was so much after that. There were disciplinary issues, and then SFIO had its own investigation, and which led to a PMLA matter being filed in the PMLA appellate tribunal. So just see one sting operation done on one of those spy cams in different branches, the kind of ramifications it entailed. So of course it's not a senior management exit, but it is similar when you have a senior management exit. I mean, if you just see the recent senior management exit from a bank, it has created a flutter. People have been wondering why, what happened.
Sure, absolutely. Too many questions, as I said, coming in from different sides when something like this happens. So you have to be,
Yes.
you know, be able to justify. Not an easy position to be indeed for any organization. So thank you so much for putting it together. This brings us to the last question, Ruchi, which is in situations like government contracts or unequal bargaining power, where negotiation flexibility is limited, how can businesses still adopt a strategic approach to dispute resolution?
Yeah, so Neha, this is a situation where one has completely unequal bargaining power, right? The bid documents are already prepared according to standard templates by the government departments, by the ministry, or whichever, whoever. Um, they are being governed by the Central Vigilance Commission, etc., etc. So they are not going to even give you 1 inch of negotiation capacity. You
Right,
can't really change anything, right?
right.
Uh, you will be permitted to do a survey or not permitted to do a survey. If you have to give a lump sum quote, you will have to give a lump sum quote. You can't back out from it. You will have pre-bid queries. You can, ask for certain clarifications, but the negotiation legroom is next to nil. That is the first thing.
Hmm.
It's very unilaterally drafted. It's standard template documents at the bidding stage. Finally, they have no option but to award it to L1. I mean, once the technical specifications, once you've won the technical round, and you've been allowed to go into a financial round, they have no option but to give it to L1. Doesn't matter whether you are ready to offer a better technology, you are ready to do things that are better in a better way, but obviously it's going to be slightly more expensively priced. It doesn't matter. You are not L1, you lose. So even if you go ahead and you try and fight and litigate and say, why was I not awarded? I'm more technically proficient, I have better technology to offer, etc., doesn't matter, right? Once you've cleared the technical round, all people are considered equal in terms of technical specifications, and then it is down to the lowest price bid. So that's one thing that you need to understand, which of course all private sector enterprises already do understand. Uh, but working with the government is something where, uh, I'll give you a practical example. Let's say it's a lump sum turnkey contract or something, and the government is supposed to give you a right of way or something like that, and they're unable to give you the right of way, and you get delayed, and therefore the costs escalate, or you have an escalation claim, or there's an extension of time claim. The straight answer from them will be, this is a lump sum turnkey contract, you are not entitled to any escalations, etc., whatsoever. Then obviously you go and you arbitrate, and you present evidence before the tribunal, and you show exactly how there has been contributory negligence from the government end or the public sector enterprises end, etc., etc. You win an award, you get an award in your favor. The government is going to appeal it, appeal it, appeal it, and appeal it till it reaches the Supreme Court round. So you will not be able to execute or enforce that award. And there are multiple judgments about this. It will be like, let's say it's an award that you got in 2010, you still would not be able to have been able to manage to enforce it in 2025 or realize the money against it. So, because government, nobody will settle. If they settle, it will be shown as undue bias, favoritism, or something like that. That particular official who has signed off on that will have a vigilance inquiry against him or her, etc., etc. So they're going to litigate, litigate, and litigate, and they're going to exhaust all remedies. And unless and until the court orders them to pay that money finally, right up till the Supreme Court, they are not going to pay you, even if they're like a government sovereign body and they have enough. So it is so your risk appetite and your ability to handle this kind of a normal MNC would simply not be able to do this. They would simply not get their heads around. They would therefore never go for a government contract or a government tender, right? So this is where the government, where the government is one of the contracting parties. While there are judgments to say that it has to be very fair, reasonable, and you have the ability to file a writ petition as a violation of your fundamental right to do business, etc., etc. But this is how frustrating it can be.
Absolutely, very well said, and a classic example, of course, to back that. Thank you so much for your insights today, Ruchi. This brings us to the end of this masterclass, and it was my pleasure hosting you today. And this dialogue has actually reinforced a critical perspective, which is conflict is not always a setback. Sometimes it's an opportunity to strengthen the governance and decision making, and actually the long term resilience that everybody keeps looking for. So, thank you so much for sharing your thoughts today.
Thank you, Neha. Thank you, HRAI.
Thank you. Thanks a lot.
Thank you.